All right, welcome everybody to our hopefully first annual Lerch Brewer Employment Law Day. I'm thrilled to see all of you here today, both on the Zoom and in person. For those of you who I haven't met yet, there's a lot of familiar faces, but my name is Jessica Summers. I'm one of the co-chairs with Marc Engel of the Employment Law Group here at Lerch. We're thrilled to have everyone here. Just logistics for those of you in the room. We've got snacks and coffee at the back. For those of you on Zoom, there is an opportunity for you to put questions into the chat bar. We will be managing questions as we go through. So if you have any questions, please let us know. We have a lot of folks who went into making this a wonderful event today. Thank you to our marketing team, Scott and Alejandra. Thank you to our admin team who set up the room for us, set up the food, to our IT team for making sure that hopefully everything goes smoothly. You can hear and see us all. To our management team, we've got our managing partner, Ruth Katz, in the back. We appreciate your support of kicking off this event. And of course, to my colleagues in the Employment Law Group, we have almost our entire department here to present for you today. So it's a great opportunity for those of you who've worked with one of us or a couple of us to get to know all of us and to put faces to those voices that you hear on the other end of the phone. So as we kick off the presentation, one of my mentors used to say that having employees is one of the most highly regulated industries that you can be in. And all of you in this room are nodding your head because you're in the HR professional area, you manage employees, and you know that that's true. One of the things that makes our profession really exciting is one of the things that makes your life difficult, in that this law is always changing. We're always having new developments. We're always having new nuances. So while that's exciting and interesting for us, it can be really tough for you all. So the purpose of today is to try to get together, discuss some of the big issues that we're looking at, give you some things to think about, give you some information to take home, and hopefully we can continue to have that dialogue after the session and as we go through the year. And of course, we're always here for you if you need our help. So we're going to kick it off with Jim Hammerschmidt and Marc Engel. Just for the presentation schedule, for those of you who are want to know when you're going to get breaks, we're going to kick it off with Jim and Marc talking about restrictive covenants. We're going to move on to Julie and Matt discussing AI and employment law. Then we're going to take a brief break, move on to developments in pay transparency with Mike and Nicole. And then Jace, Lori, and I will close it out with a hot topics panel. And we'll be wrapping up around 4 o'clock. And then for those of you in the room, please continue to join us for a networking reception. So without further ado, Marc and Jim.
Scott, you want us?
Yeah, go ahead and
Be up here so we have a clicker.
are you starting?
Do I need to use the microphone? Okay, so geez, this session that Marc and I are going to do could have been very, very different. We were sort of waiting to see how this was going to play out as the courts kind of wrangled with this the FTC rule and not the piece. So as it turned out, we don't have any national sort of landscape, which is good and bad. Like everything else, it increases the fact that as employers, we have to deal with 50 different states instead of having one rule to play by, right? And so Marc and I are going to talk about, I'll just cover the FTC rule just a little bit. And then I'll do a quick DMV update. Everyone understands what's happening in our local jurisdictions. And then Marc is going to talk about some best practices in dealing with what I like to call employee mobility. That's kind of the newest kind of jargon for what this is all about, is allowing employees, right, to have maximum mobility and not be restricted where they can work as they transition from employer to employer. So real quickly, we had the FTC rule that was proposed in January. It took about 16 months for the Federal Fair Trade Commission to adopt the final rule. And when it was adopted in April, obviously caused a huge uproar because it was basically, much to the chagrin of many employers in many states, almost a complete ban on non-competes, with just a few exceptions for senior executives who already had non-competes in place, an exception for the sale of business, a business sale, a bona fide business sale, that kind of thing. But it didn't take long. I think that some conservative groups had kind of the pleadings in the can, and they were ready to go once the FTC adopted the rule, and there was immediately a case filed at Ryan LLC versus the Federal Trade Commission, which teed up the issue of whether or not the FTC had the rulemaking authority to make and adopt this rule. And it's not often that what we do in day-to-day business is on the front page of the Washington Post, the New York Times, NPR, leading sessions with it, that kind of thing. But obviously, most people know about this because it did get sort of global attention almost. But the Ryan case that was in the United States District Court for the Northern District of Dallas, very conservative jurisdiction, handpicked by the plaintiffs, right? And the judge there agreed ultimately, after a preliminary injunction, entered a permanent injunction and entered a ruling in favor of the plaintiffs, in favor of Ryan LLC, that said that the FTC rule is arbitrary and capricious, it exceeds their rulemaking authority, and they not only set it aside, but enjoined it from taking effect anytime thereafter, and made it a nationwide injunction. So far the government hasn't appealed to date. I find that it interesting. I always felt that the rule was probably going to get knocked down, but I also felt that it was the government's attempt to sort of throw something out there for others to kind of grab onto, even if it got struck down. My view, was kind of an expensive PR stunt, frankly. Many people would disagree, but I think it was clear what was going to happen to that statute. But now it's out there, so it can serve as a role model for states that haven't yet moved in the direction of prohibiting restrictive covenants. So far, 14 states plus DC have passed laws banning non-compete agreements in various forms. Some jurisdictions have taken kind of a very broad approach to it and almost completely put in a near total ban or a total ban. California, we know about that. California's been that way for a long time. North Dakota, Oklahoma, Minnesota, and DC, and we'll talk about DC in a minute. Several states have targeted specific groups or industry groups. So several states have bans targeting low-wage earners or middle-income earners, hourly workers, specific industries. The healthcare industry is a popular one that's being dealt with through statutory restrictions. And like I said, the FTC rule may provide a roadmap for future state and local legislation. There are some states that have balked at FTC-like bans. Recently, the New York governor vetoed significant legislation that was under pressure from Wall Street. Rhode Island, the legislature had passed an outright ban, and the governor vetoed it on the basis that they felt it would put the state at a competitive disadvantage. And then the Maine governor also vetoed a congressional action in that state prohibiting restrictive covenants or non-compete agreements based on the fact that it was just too wide-ranging, that there could be more targeted approaches to it by the legislature. So what kind of things are we seeing that these statutes are sort of creating a movement on? First of all, we're seeing statutes where there are notice provisions in the statute, right? So if a state passes a statute, it says the employer has to provide notice to their employees. The notice has to be provided within a certain period of time. So maybe it has to be provided 14 days before being hired or 30 days before being hired. The notice is mandating that substantive information be included or provided to the employee about the state's law and restrictive covenants. They're adding private rights of action. So if an employer attempts to unlawfully enforce or threaten to enforce a non-compete, an employee can bring his or her own lawsuit against the employer for doing so. They make it a misdemeanor. So there are monetary penalties for attempting to enforce a non-compete or threatening to enforce a non-compete. Some states are placing upper limits on the temporal or geographical restrictions they can use. They're having industry-focused laws. So all of these things we're seeing baked into the various statutory restrictions that are being passed in various states, and we'll see some of those in our own local ones. So Maryland passed a statute in 2019. Essentially, it's a low-wage earner statute, and it all employment agreements are null and void if they restrict the ability of the employee from entering into employment with a new employer or for becoming self-employed. Now, it does not apply to agreements prohibiting the taking or use of client lists or other proprietary client-related information, and that's something Marc's going to talk about when he gets there. The Maryland statute, when it was originally passed, it says the non-compete restriction is on anyone making 150% of the state minimum wage. So in October of last year, it was $41,350 annually, and this year, January 1, 2024, the current threshold is $46,800. So in Maryland, you can have a non-compete; they're still viable, but you cannot have it with an employee who makes less than $46,800. And this year, again, kind of an industry-focused add-on, the Maryland legislature passed an amendment to the statute which restricts non-competes and places a complete ban on veterinary technicians. So your dog and cat are safe. Go with your veterinary tech wherever he or she goes. The veterinary practitioner and a healthcare practitioner who makes less than $350,000 in total annual compensation. But even then, and here we get into some of the nuances, right? So now we got an industry-specific statute, and we also have a statute that places upper limits on the duration of the non-compete. It can't last for more than a year. It places a geographical restriction. It may not exceed 10 miles. And it also has a provision that if the patient, the employer, or the employee requests a notice, it goes out to the patient of the new location, and that has to be sent. DC, that they fall in the category of placing a nearly complete ban on non-competes. The law forbids agreements or policies that prohibit an employee from being employed by another person or another company, both during employment and after the conclusion of employment. And it applies to all workers who spend at least 50% of their work time in DC, or they work for an employer and regularly spend a substantial amount of work time in DC, but not more than 50% elsewhere. What is a non-compete under the DC statutes? It's a provision in a written agreement or a workplace policy. What's going on this guy? Or a workplace policy that prohibits an employee from performing work for another for pay or from operating an employee's business. And a workplace policy includes both a written and an unwritten policy that would restrict the employee from post-termination employment elsewhere. It's not retroactive. It only applied to agreements entered into after October 1 of 2022. But as I said, it applies to all workplace policies, whether they're written or unwritten. It does have some exclusions for highly compensated employees, medical specialists, babysitters, partners, and buy-sell agreements. So again, you're seeing some of the nuances that are trending in various jurisdictions. I think one of the most interesting things that catches some of our clients off guard is the DC statute is kind of it's a moonlighting statute. It prohibits employees or employers from enforcing moonlighting policies. So we'll see. It's one thing to have a written non-compete agreement, but what we've seen in a lot of old handbooks, particularly, is these policies that prohibit employees from moonlighting, doing second jobs, or other type of work besides just with the employer. And the DC ban really encompasses, it prohibits those types of moonlighting policies unless the second job will result in the disclosure of confidential information or it will violate the employer's established rules regarding the conflict of interest. So one of the workarounds that we do for clients when we're thinking about this, particularly if we're talking about redoing handbooks, is to think about having conflict of interest policies that are legitimate, but that will address potential moonlighting problems. If an employee falls with one of the exclusions and an employer wants to use a non-compete, there's a statutory notice that has to be included, and that's the language directly from the statute. I think we covered workplace policy requirements. Also, if an employer wants to use a non-compete, they have to give the employee notice of that non-compete before the employee is hired. And the DC statute prohibits retaliation against an employee for refusing to agree to a non-compete or to comply with non-compete provision. So, theoretically, if the employer wanted to try to use a non-compete, and the employee says, no, I'm not going to sign it, there can't be any retaliation for the employee's position on that. There's some record-keeping requirements. Those have not yet been issued or promulgated by DC, so we're still waiting to see what that's going to go about. Virginia also has a non-compete statute, and it's basically a low-wage earner statute, not unlike Maryland statute. The difference is that Maryland is using the minimum wage to establish what a low-wage earner is. The Virginia statute uses, since we have it there. Yeah, a low-wage earner is someone who is earning less than the average wage for the Commonwealth of Virginia. So it's a moving target on a quarterly basis. You go to the state website, and you get the particular threshold that's being used in any given quarter. A low-wage earner is defined as not only an employee, but an intern, an apprentice, a student, a trainee. It applies to independent contractors, so that's another trend that we're seeing with states that are passing restrictive covenants. And interestingly, in Virginia, the definition of a non-compete is a provision of an agreement that restrains, prohibits, or otherwise restricts an individual's ability to compete with his former employer. The prohibition includes prohibiting employees from providing services to any client or customer client if the employee does not initiate contact or solicit the customer. So that has kind of a non-solicitation provision in it too. Most statutes are not addressing non-solicitation. Marc's going to talk a little bit more about what that is. Let's see where we're at here. All right, so that's the lay of the land, both at a national level and at our local state level in DC, Maryland, and Virginia. Marc, you're going to roll with some of the takeaways from all this.
Thanks, Jim. That was an excellent presentation and overview of a complicated area. So let me try to provide sort of a different framework or a paradigm for thinking about non-compete and post-employment restrictions from a couple of different perspectives. Because I've got some views on this that I think want to challenge maybe some of the orthodox ways in which people think about non-competes, to see if there's some new and creative and imaginative ways to kind of address the concerns that non-competes were designed to try to address many, many years ago. Okay, so if we zoom out for a second, what we see is a non-compete at its core is really is a restraint of trade, right? It's an inhibition against movement of employees. And it's become, as Jim indicated, very, very much a political issue all across the country, locally, statewide, nationally. It's a hot potato. For some politicians, it's low-hanging fruit to be on one side or the other without getting political about it or taking positions. It kind of is what it is, and that kind of ties into what the economic landscape looks like. Okay, and so there's a lot of correlations. So what Jim articulated and really tried to and did it in a masterful way, and some of the through lines that I see from these statutes throughout the country, right, is that there's barriers. If you want to have one of these restrictions, we're going to make it tougher for you employers to comply with it. Okay, intentionally. We're going to require notice, as Jim mentioned, in certain instances. We're going to make sure you dot the I's and check the T's when it comes to so-called low wage earners. So Jim was mentioning in Virginia, I think you've got to go to the website, you've got to check the index, you're going to have to, and in Maryland, you've got a different formula for gauging whether someone is a low wage earner. Right? So we're seeing sort of a pattern, sort of a through line to what the legislature in these jurisdictions is trying to communicate. Okay, if you're going to go ahead and use these things, all right, we're going to make it challenging for you to do so. And we're going to hold your feet to the fire if you footfall. Okay, so it's really important to kind of keep that context in mind. Number one. Number two, if we again look at this from a broader view, it's important to understand at the outset when people use the term non-competes. And if I'm getting a little basic here, forgive me, but we're really talking about four different things. People use that term interchangeably, and they assume that when people use the term non-compete, that we're all speaking the same language. But I like to look at it as really four different things. Pure non-compete, which is you can't go out and hang out your shingle next door. The non-solicitation, which comes in two flavors. A non-solicitation of clients and customers on the one hand, and non-solicitation of employees on the other. Okay, and then we've got confidentiality and trade secrets. So if we look at the courts, and Jim, please chime in terms of the enforceability of these things, right? Courts are going to, in my experience, generally go ahead and look at confidentiality provisions, and they're going to use those pretty favorably. They're going to be generally well received, unless they're really overbroad in a way that really just, kind of shocks the conscience. Okay. Then if you look to non-solicitation of employees, right? Courts, in my experience, are going to go ahead and give that some bandwidth as long as there's some guardrails baked into what it means to be an employee. Is it anyone who's ever been an employee in the history of the company? Well, that's going to be a problem. Somebody who was an employee 7 years ago, 10 years ago. So again, drafting is a huge issue. The non-solicitation of clients or customers, as the case may be, right, is going to focus on how client and customers are defined. Lori's had litigation over that issue. I've had it. Jim's, I'm sure, has had it. Okay, how is client or customer defined in the agreement? If it's for IBM, can I not solicit every employee, every customer that ever was a customer or client of IBM? Of course not. If I'm a government contractor, can I not ever work with an agency? Okay. So again, drafting it becomes paramount and the scope becomes paramount. All right. And then confidentiality, we're looking at things like trade secrets. We're looking at what steps the employers have taken to go ahead and protect the confidential information. So we're really talking about four different things. And it's really important to sort of keep that in mind. I think Jim's absolutely right, although the FTC rule has been stricken down for now. We'll see what happens, in November and after January, depending upon the outcome of the election, as to whether or not this issue surfaces again. And I think Jim's absolutely right that this is sort of an invitation to folks to be thinking about this issue in a different way. Okay. The multi-state implications of these non-competes is a headache. Okay, to put it mildly, it's very, very challenging to go ahead and manage all these state laws, particularly in the remote world that we're in. And Jim, I'm not sure if you've got your handle on this, but for all these state laws, do they apply to people who are working remotely outside those states and jurisdictions? Okay. And what happens if somebody moves to yet another state? Okay. So again, we begin to see the complexities of trying to manage this situation. One of the takeaways that I look at and that I recommend, if you jump ahead a little bit, is inventorying what non-competes and restrictive agreements we have. Mike Neary and I have talked about this before. We have a client when you're about to enforce one of these agreements from the litigation standpoint, and lo and behold, there's 4 or 5 versions of this thing floating around. Okay, some apply to certain employees, some were entered into 3 years ago, 5 years ago, 2 years ago, 6 months ago, 2 weeks ago. Okay, so that matters. So it becomes a challenge to administer these and to keep track of them, right? And then what may be perfectly fine in Maryland Okay, may not fly if you've got employees in California. So how do we draft the carve out? Okay, how do we draft the exceptions? Who do we want to have it apply to? So if we start looking at these through lines, we see the challenges that they present, and all of us in the group have dealt with these to one extent or another. So another theme is kind of zooming back out and saying, what do we really need these non-competes for? What purpose are they serving? Okay, when I ask clients that question, a lot of times I'll get the response, we've always done it that way. Okay, it's just the way we do things here. My predecessor had them, his or her predecessor had them, our competitors have them. Really, which ones? I don't know, but I'm sure they do. Okay, so again, it's become sort of conventional wisdom, and I'm not sure how wise they are. That's what I'm challenging employers to think about. Is there another way to go about achieving the goals which non-competes, if you use those 4 items collectively, are designed to achieve, right? So, for example, with salespeople, right? Classic situation when someone's going to go solicit a client, but someone leaves. Okay, these non-violations of a restrictive agreement become personal. Okay, the first half of my career, I did all sorts of litigation, business litigation, but there's nothing other than domestic, which I'll leave to another world. It's all into itself. It really strikes to the heart of employers, like employment litigation. Okay, the rationality could sometimes go out the window when somebody is leaving, because there's a sense that somebody's been dishonored, somebody's violated, okay, a rule or regulation or a policy or the way we do things, and how dare they leave? And we're going to show them, okay, because we're going to send a message, and that non-compete or the non-solicitation is going to be a way in which we're going to go ahead and let them know who's boss. Again, some of these are just some of the things to be thinking about, okay? But if you could take the confidential information and we could safeguard and password protect all the trade secrets, all the confidential information, and if we could go ahead and remind employees when they leave in a friendly way, this is to remind you that if you haven't already done so, please return all the documents and information belonging to the company. As you can appreciate, we take this very seriously, and we ask that you do as well. Please return them immediately. We also want to remind you, as you leave, while we wish you well, of your ongoing obligations to the company, including confidentiality and your duty of loyalty. Okay? So there's ways to perhaps get that message across when someone leaves that isn't necessarily a demand letter or a threat of litigation. Okay? Non-solicitation of employees. Let me jump to that for a second. When employees are leaving, okay, I ask, sometimes the freshness of it, right? The anger of it, the annoyance of it, and the fact that I got to go find another employee seems to predominate the discussion. And then when you peel it back and 24 hours pass, and you ask, how concerned are you about that person being a threat to you? Are they really going to go take your clients? Would any client actually follow them? Or is it like passing a bad penny? They're just going to be somebody else's problem. And all of a sudden, maybe there's a new way of thinking about whether I want to be aggressive in enforcing this. Okay. Now, if there are bold violations of people taking trade secrets, Jim and I have talked about, people taking things that don't belong to them. In my experience, courts, judges have no patience with it. Okay. And these become stronger cases, easier to get an injunction for, easier to win at the end of the day. Okay. But again, we want to be judicious about how we think about these. Are they really serving our purpose? Is there another way to do that? Is there a way to go ahead and narrow the focus of these non-competes and these restrictive agreements to really look at how they're tailored to our particular business in our particular industry? Okay, and that requires some rolling up the sleeves, and it's a bit of a heavy lift to do so. But my challenge is that I think that time spent in going ahead and reviewing those with the assistance of counsel, so that those communications can be privileged, right? You can have a very healthy discussion of this. This is going to pay off in the long run. You're going to get consistency in terms of what you choose to do and how you choose to enforce it, right? Okay, you're going to look and figure out what your inventory of these restrictive agreements is. How many of these darn things do we have floating around? It's nuts. Okay, number three, we're gonna realize that one hat size doesn't fit all. We can't have a restrictive agreement for our C-suite executives. It's the same one we give to a mid-level manager, nor should we. And we're gonna look at this whole concept differently, because remember, if you're looking at an analysis of these non-competes, you're gonna start with this, are they statutorily banned? Right, Jim's talked about that. Okay, even if they're not, courts, when they, in terms of enforceability, are gonna look at whether or not they're reasonable. Typically, that's gonna involve whether they're reasonable in scope and duration and geography, in a general sense. So just because a jurisdiction doesn't have a state law, okay, that prohibits non-competes, doesn't mean that's the end of the analysis. It's really the beginning of the analysis. Okay, so we're gonna look to that. That's gonna be step one. Step two is our agreement, is a court gonna enforce this? Number three, do we wanna seek to enforce this? And what's gonna happen if we do? Okay, what kind of counterclaims might we be subject to if we try to enforce this? What's the litigation likelihood? How is someone going to receive this? Right? Do we have pending concerns about wage and hour claims going to come back in the other direction? Do we have insurance if we get countersued? Have we been consistent in how we've enforced these restrictive agreements? Right? There's an entire website, I think it still exists, and you know, with the plaintiffs part devoted to, you know, ways in which to find challenges to non-competes and employment restrictions, because maybe there was a lack of consideration. Okay, some states may require consideration other than just continued employment as a basis for enforceability. Number one. Number two, there can be an argument that the employer breached its agreement. I've had clients that have not paid employees certain money, saying we can't afford to pay them right now. And when the employee leaves, they want to try to enforce the non-compete. So what universe do you think a court's going to enforce that? Okay. Despite the pretty language that we might put in the agreement that there's no offset to a claim if you violate one of these covenants. Okay. How is it going to be met? How is it going to be perceived? So we've got statutory analysis that we're going to look, does the law ban? Number two, is it going to be enforceable? Number three, have we been consistent? Number four, do we even want to bother to go ahead and enforce it? And what's going to come back to us if we do? Number five, what are our competitors doing? What goes around comes around. If we're trying to enforce the very same agreement that the person we're hiring has the very same restriction, and at the same time we're trying to enforce one of these, we're trying to hire someone who's got a restrictive agreement, we may be inviting a tortious interference claim. Make sense? In other words, if somebody leaves an employer, right, and they go to a new employer, the old employer says to the employee, you're violating the restrictive agreement. And by the way, employer number two, you're interfering with my contract with the employer. So again, it's important to take a holistic look at these things. Okay. What's going on in the particular industry? How are non-competes and other types of restrictions viewed and considered in your industry? Mike and I are dealing with a case right now where it has to do with financial services. There are specific rules, guidelines, policies, procedures, protocols, whatever, that may apply in a particular industry that may have to be considered when you go to enforce one of these restrictive agreements. Okay. Are the post-employment restrictions from a business standpoint, and we're running a little bit low on time, are they competitive? Are they serving your competitive a competitive purpose, or are they not serving a competitive purpose? Okay, what do I mean by that? The old school way of thinking about these things was that they would protect goodwill, they would protect client relationships, they would protect all the things we tried to do to run our business. And from a competitive standpoint, we need to have these in place, or our business is going to fall by the wayside. Okay, that was sort of the logic of this thing. And it made sense, and it may make sense. certain situations. Okay, but is it really serving your competitive purposes? And how? It's just a fair question to ask. Ask it with counsel, kick it around, okay? Or is it actually, ironically, almost anti-competitive? Because if we have one of these, are we expecting our competitor to have one? Where are we, is it going to be an impediment to us hiring employees? Okay, because we're going to tell them when they come in the door, congratulations, we're going to pay you a little bit more money, okay, than your prior employer, but we're gonna saddle you with a 2-year non-compete. Okay, is that going to be an incentive to getting somebody hired or a disincentive? Would a 1-year non-compete apply? Okay, should there be carve-outs for the non-compete if somebody is let go? If there's a termination without cause or a layoff? All good questions to ask about, you know, do we want to have these ourselves? Another word about non-competes and restrictive agreements is where they can be found. Typically, you'll see them in a standalone agreement. Okay, but all of us who do this kind of work have seen them in stock agreements, buy-sell agreements, partnership agreements, sometimes even in handbooks, okay, and sometimes in offer letters, sometimes in side memos. So again, we want to make sure we know the lay of the land, okay, to make sure we've got the full universe of the restrictions that are applicable. Okay, because if we don't have that full universe, we may be enforcing or attempting to enforce the incorrect document, or attempting to enforce a document that's inconsistent with another corporate document that we may have in place. Borrowing restrictive agreements. Let me try to say this diplomatically if I can. We all see this from time to time. I certainly do, where you get a restrictive agreement that your client is using, or that somebody else is using, or you're asked to review, and it's got the name of some other company in it. Okay, and some other industry, and it refers to things that your client doesn't even do, and yet we've been passing those out like they're, you know, and using those without any kind of real consideration because everybody's got one. So again, really important, if you're going to use these restrictive agreements, let me kind of wrap up here. My challenges to you are the following. Number one, inventory what you have. Number two, with counsel, so that you can keep these communications confidential, decide whether or not you need them and to what extent. Decide who you need them for and why. Okay, have consistency and an internal group that analyzes when and under what circumstances you're going to go ahead and seek to enforce these. Okay, and take a holistic look where you do find out what might be coming back in the other direction, and then have folks within your organization commit, if you're going to be using these non-competes, if you're going to be using them on a multi-state basis, to monitoring where our staff is, where our employees are, and who has which agreement.
Yeah, that's true. I think that's vitally important because if this FTC bill comes back around, if you recall last time, it had a provision in it that you had to notify all of your employees who were subject to a non-compete. And what we found with a lot of clients is they just didn't have the inventory. We weren't really sure who they had that was subject to a non-compete. And so inventorying, knowing where they are, knowing who's subject to them, and many of the states that are passing, you know, statutes are incorporating similar provisions. So there's this notice element that really kind of makes it absolutely critical that you know who has them, where the employees are located, and what they say.
And I think at the outset, let me just close with this. I think Lori would probably say this, and Lori may want to chime in, or Mike or others, that a lot of these non-compete cases, you know, are really won or lost at the injunction phase, right? So the issue is, can you convince Lori Cleary, right, before you're going to run into court, that you've got an enforceable agreement, right, before you have to present it to a judge, right? Because when you're going in for an injunction, that's usually going to be the precursor of what's going to happen for the rest of the case. Okay, so in many of these instances, in many of these cases, unless somebody's really, they're stealing something, okay, if these confidential information, trade secrets is about to go out the door, Okay, I get it, it's DEFCON 5, an emergency is apparent, and people want to make a decision in 5 seconds, I get that. But in many instances, taking a step back, exhaling, looking at these things, deciding on a strategy, okay, and spending 24 hours to reflect on these things can really help shape your strategy going forward. Not only with respect to that particular individual, but with respect to other individuals. And one final word before I forget is that if you do have a situation where you haven't restrictive agreements and they haven't been dusted off in years, they're out there and they're in place. Okay, they just are where they are. They've been out there for 5 years. Okay, and Lori tells you, what the lawyers here tell you, gosh, you don't want to go to court on that, okay, because you're not going to be able to enforce that version of the agreement, right? You're better off starting fresh and getting this done correctly. Because the last thing you want to have is clever plaintiff's attorney coming back at the other end of this, filing a declaratory judgment and seeking to invalidate every single restrictive agreement that has the same terms. So with that, I will wrap up. Anybody else in the group want to add to that discussion? No.
Thank you, guys. So for those of you who are on the Zoom, we've seen a couple questions come in. Unless they naturally fit within the presentation, we'll be taking those at the end of the rapid fire Q&A, so that we're not breaking up the presentations for our presenters. But continue to submit your questions. Don't worry, we will get to them. Now I think we're on. Yeah.